So welcome again to our this patent agent exam preparations. So now we are going to discuss from section 99 to 103. This is comes under chapter 17, use of invention for the purposes of government and acquisition of inventions by central government. So again, I would request that please keep reading the text from the Patent Act as they are given and make yourself habitual of reading and understanding from there. This presentation is just for to guide you for the exam purpose, but you should not take this presentation as granted. Always refer to these books because in your real life, in real situation, you will require to read the sections, and whenever there are some changes, as we discussed in Tribunal Reform Act, those changes you need to read yourself independently and interpret. So what happens in the courts is the way every lawyer interprets the laws given there. So you need to have your own interpretations, but your interpretations should match with the, I would say, 99% of the other similar fellows. It should not be more deviated from their understanding. So please keep reading this acts yourself. But for exam purpose, I feel that this PowerPoint presentations, whatever is given there, will also be help to you. But after the sessions, you can watch these videos again and again. But please, what to suggest that please read the sections in the Patent Act also, and then try to map whatever is given in the sessions are correct, or there are something which requires some modification, and you can let me know. We can discuss, and if there is a major mistake from my side, we can add some comments in the video so that anyone other than watching the videos will help them. And I would say that the way we are doing this presentation, you will not find this kind of discussion and this kind of simplified presentations too much on the web. So let's start quickly. So this section 99 says meaning of the use of invention for the purposes of government. So whenever this phrase comes about the use of invention for purposes of government, so there is a very nice case study. We will discuss that case study while doing the case studies. So we are not going to do it now because that would divert our attention to different topics. But use of invention to the purpose of government, what does this mean? One, an invention is said to be used for government when the invention is made, used, exercised, or vended for the purposes of central government, state government, and a government undertaking. Okay. This chapter is different from the as mentioned in section 47. Okay. What is section 47? Section 47 says a patent is granted under the condition that government can use it for its own purpose. So always you need to read this section 99 and 47, and there is a very nice case study on this. So what it says, again, okay, it will come later on. So section 47, what it says, that grant of patents to be subject to certain conditions. One, government can use the invention or import patented invention for its own use. Okay. So what is the difference that you see here is, I will ask you, okay, and if you can't tell, I will mention this. Patented process can be used by government for its own use. Okay. For patented invention can be used merely for experiment or research, including impartial instruction to people. So this is section 47 that we are reading. So 1, 2, 3, and 4. For patented drug, government can import patented drug for its own use for distribution in dispensary, hospitals by notification in official gazette. Can you make distinction between section 99 and 47 based on what is written here, how they are differing, because section 99 it says that this chapter is different from as mentioned in section 47. Can anyone make any difference? What is the difference in both the cases? You notice the wordings, right? How the words are written, that makes the difference. No answer? Anyone would like to try? It may be mistake or doesn't matter, but if you try, then you will remember much better. Okay. See here what it says: use, used by, on use, used merely. Okay. Imparting instructions. Government can import. Patent drug only. Okay. Not other things. Okay. For every other things, it is use only. Government can use patent process. Patent process can be used mainly for experimentation. Patented drug can be imported. So other things other than drug, it is not saying about the import. If it is drug, government can import drug. But if it is, for example, mobile phone, laptop, or anything other than the drug, section 47 does not allow government to import here, according to section 47.4. Section 99, what it says, it uses different words. Invention is made, exercised, or vended for the purpose of central government, state government, and government undertaking. Is it clear? Are you there or not?
Yes, sir.
Yes.
Yes, sir.
Is it clear now?
Yes, sir.
Clear, na? So section 9, it says, it talking about the made, means it is made. I mean, if I have a patent on mobile phone, so that can be made in India for the purpose of central government. Okay, and some vendor can apply for it for the purpose of government. But section 47 says, if government is going to use this mobile phone, it is not talking about government is making mobile phone. Okay, government can use this mobile phone for its own purpose. So that is section 47. Is it clear now? So
Yes, sir.
making and using are two different, right? Making and using are two different things. Making requires, means government has set up some plants. They have started making the mobile phones. Okay, so that comes under section 99. Okay, but government is using the mobile phone or the technology for its own purpose. They are not going to make. They are not. They are just using the patented process can be used by government for its own use only. Okay, but making an exercise or vended. So these are the differences between section 99 and 47. There is a case study. When we study the case study, you will come to know in more details. Now we will read other sections in this chapter. Section 100. Power of controller to use invention for the purpose of government. So section 99 is defining only that what is the meaning of purpose for the purpose of government. So purpose of government means can be made, used, exercised, or vended for the purpose of government by central government, state government, or government undertaking. So this is the difference. Okay, and section 100 says power of central government to use invention for the purpose of the government. So what is the power of central government? So we'll discuss more. So one says central government can use the invention for the purpose of government anytime after the application for patent is filed, okay, or the patent is granted. Okay, they can use anytime. So once the application is filed, they can use, and even the patent is granted, they can use. Next, government can use invention without any remuneration to patentee. So what we expect, that if I have filed the patent and government is using it, then government should pay some remuneration. That is the way I will be benefited. But there is a clause under section 102. It says government will not pay any remuneration to patentee. What is the condition? There are some conditions. If invention before the priority date of the claim in complete specification was duly recorded in a document or tested or tried by or on behalf of government, note any communication to central government about the invention for any other purpose is not considered here. What does this mean? That if you are working on an invention for the government, okay, or on behalf of government, I mean in government labs and other things, okay, then that if government uses this, then they are not going to pay any remuneration, in a simple language. If you're working in government lab and there's an invention and government uses it, they will not give any remuneration. Okay. If subsection 2 of section 100 is not the case, means the invention that I was working on was not done on behalf of government, okay, then government will pay patentee for using the invention after the grant of patent. So if they are using the invention after the grant, then they will pay some remuneration. The terms and conditions can be agreed between patentee and the government for the use invention. And if we have any disagreement, you can go to High Court. Okay. Government will not pay more than the economic value of the patent. Okay. So there are many terms and conditions. I mean, how much R&D money was spent on then drafting of the application, then filing fees, everything will be considered. And again, how much profit you are going to make, everything that is there, that will be considered. But the things we need to remember here is very simple, that government can use our patent application after filing and after the grant. And if the invention was done on behalf of government, then government will not pay. This is very obvious. Why government will pay? You are working in the government lab, you made them some invention, and again you say the government should pay the money for my invention. So that will not be the case. But if we are not related to government, then government will pay the fee. So that comes under section 103. And then 4 number, the authorization for use of invention can be given by central government before or after the grant, before or after the use invention. So, and maybe given to any person, even if it's not be authorized by patentee applicant. Patentee cannot choose a person whom government will authorize. Okay. So government can give in writing. They need to give in written disclosure that this is going to be used for the purpose of central government under this section 100. Okay, section 99, section 100. They need to give in writing. You cannot assume that because, say for example, the case that is there, it is regarding. You must have seen in when you come to this Pune, okay, and the Pune-Mumbai highway. So on the rocks on the hillside, you will see there are nets. Okay, those nets are there in place so that they protect falling of rocks on the road. And Garware ropes, they had the patent on this. Okay, and they were working with the railway department. Garware ropes and railway department, they're working together. But some other person who used that same kind of technology, what Garware ropes had the patent for making nets, and they signed up as a vendor for this for the government, but government has not given written permission to those persons to use it. Now Garware ropes, they sued these persons that you are infringing my rights, and then court it went into the court, and there were decisions based on section 99 and section 47. Both were discussed there, and what it was found that because this other person was infringing, he applied that, yes, I want to the vendor, I mean, I want to make this, and they had the agreement and they were working on, but government did not give in writing that you can use this patented invention by Garvai ropes for the purpose of the government. So that letter was not there in place, and therefore they had to pay the money to Garvai ropes for infringement. Is it clear? So government has not given any return. So government has to give authorizations. So government can authorize before or after the grant. Government can also authorize before or after the use invention. So this person, what they could have done is that they may, before the filing of infringement suit, they could have gone to government and said that although we have not taken permission from you before, but can you give in writing that you authorize us for using this patented invention by Garvai ropes for these purposes? But they didn't do that way also, and therefore they were guilty of infringement and they had to pay the fees. So this is the meaning of means power of central government to use invention for the purpose of government. So what are things to remember here? That government can use only by authorizations, and they have to authorize the person, then only they can use. And any terms and condition they fix it, government they fix it. If you are not happy with the terms and condition, if they are paying you less money, you can go to High Court, and the authorization has to be in written format. Section 5 says government will keep subsection 5 of section 100, government will keep patentee applicant informed about the use of invention. So it's the duty of the government to inform that this is being used. So in the Garvai rope case, what this other person could have done, that if we had approached the government, then government will notify the Garvai ropes that they are going to use it for the purpose of government. Then again, Garvai ropes will ask for the remuneration. Okay, because this then the condition need to discuss, because those were between government railway department and the Garvai ropes. Those were there the case, and Garvai ropes was one of the patentee, and the Indian Railway was there. So they didn't took any permission. If they had gone for taking permission, then government would have informed the railway, then the Garvai ropes, and then different circumstances would have been there. Maybe because this was done and tried and tested on behalf of government, they may not have to pay anything fee, or Garvai ropes would have claimed that because this is our invention, we would invest and we will not allow other person. So there could be many cases or many scenario could be there. But here is like government will inform the patentee applicant for the use of invention. Government has a right to sell on non-commercial basis the patent articles, and the purchaser also has a right to use as if it was patented. Okay, so if government sells on non-commercial basis anything patented, then anyone who purchases it, he can use again. For example, I purchased the Samsung mobile phone or Apple mobile phone, anything, or Dell laptop, and I purchased the license, and then I can use it. No one is going to sue me for anything, because the moment I pay the price, I purchase it, then I have the right to use those. Number 7, if there exists any exclusive licensee or assigner the patent, government will keep them to inform about the use of the invention. So in summary, section 100 is very simple. It says that government can use it for its purpose. If they are going to use for its purpose, they will pay remunerations, and they will also inform that they are using it. Okay, but they will not pay any remuneration if the complete specification or anything was documented, tested, or tried on behalf of government before the prior date of the claim. Means if you're working for the government, then government is not paying. So very simple language. This is section 100. Section 101 says rights of third parties in respect of use invention for the purpose of government. One, when an invention is used for the purpose of government, the existence of any kind of agreement between patentee and any other person other than central government will not have any effect. So in simple language, what it says that if government is going to use and I have patent and I have an agreement in place with some other person, then whatever be the wordings of those agreement will not affect government. If patent was assigned to patentee in consideration of royalty, okay. So then when as per section 103, okay, what is 103? 103 means government is going to pay remuneration. Subsection 3 of 103. So because I have written like this, therefore I'm reading 103. So remember section 100 and subsection 3 means government will pay for the use of invention some remuneration. So the patentee, if the patent was assigned to a patentee in consideration of royalty, then when as per section 103, if the invention is used by the patentee for the purpose of government to the order of central government, a royalty will be paid and will be divided between patentee and the assigner based on the agreement between assigner and the patentee. So if I have a patent and I have given some assignment to other party, and then we had that we will share the benefit, maybe 60-40 or 70-30, whatever the case may be. So if government is using that invention, then they will also see that whatever royalty is paid, they will divide it. Very simple and logical. If an exclusive licensee uses the invention for the purpose of government and the payments are made on the basis of 100 subsection 3, such payments will be shared between patentee and the exclusive licensee both. So if exclusive licensing, so if there's an exclusive licensee is there and he is going to use the invention, then government will pay the patentee also in this regard and exclusive license both. Okay, so this is 3. So this is all under section 101. So in basic summary, what we can say that it says that if there is some if there are some other agreements, then that will not affect for the use of purpose of government. And with regard to payment to the royalty, government to pay the royalty, it is mentioned in section 3. But if there is any assignment, if there is any exclusive license exists there, then the patentee will also get his share from the government. So that is a section. Yes.
I have a question on
Please.
this. Can you go back to this previous slide?
Yes.
Yes. So the exclusive licensee is the person who alone has the rights on the patent.
Correct.
So why the government will pay to the patentee if the rights, exclusive rights, is licensee have the exclusive rights?
So exclusive, yeah, I understand your point. So will depend on when you grant the exclusive license. Okay, so if I grant the exclusive license, then there is always some licensing fee is there related with that. So the exclusive licensee has the right to use the invention, and no other person can use it. Even patentee will also not use the invention. Only exclusive licensee can use it. But for using that, he has to pay some licensing fees. And therefore, when exclusive licensee is using for the government, if government is paying the exclusive licensing, then patentee will also get payment from the government, because I should not think that I am at loss because I have given the exclusive licensee and the government is using it. When the licensee is using it, they are also going to pay. But this will all depend based on what are the terms and conditions for the licensing fee. So basically, in what we can understand, like if I am the patentee, I deal all the research, everything I have done, I should be benefited, right? Okay. So therefore, government is taking care that the patentee is benefited in these transactions.
Okay.
Okay. So
Yes.
let me read the section 101.3. Okay. Where by virtue of subsection 3 of section 100, payments are required to be made by the central government. Okay. So then it says, or person authorized under subsection 1 of the section in respect of use of invention for the purpose of government, and where in respect of such patent there is an exclusive licensee authorized under his license to use the invention for the purpose of government, such sum shall be said by patentee and such licensee in such proportions. Okay. So what it says, in such proportions, if any, as may be agreed upon between them. Clear now? So whenever there is exclusive licensee, the patentee, there is some agreement between the payments. So government will adhere to the payment and pay the patentee also that portion, or as maybe in default of agreement be determined by High Court. And if you apply to the High Court that I don't agree with the payment that I'm receiving, I should get something different than what I'm getting now, then you can go to High Court, and then based on those decisions, you will get the payment. Under section 103, to be just, having regard to any expenditure incurred by the licensee in developing the said inventions or in making payments to patentees other than royalties or other benefits determined by reference to use invention in consideration of the license. So this 101, 1, 2, 3, there are the text written in the acts are very long sentences. Okay. What I did, I just summarized in few words so that you remember this. And thank you for asking the question, because once you ask question, it clarifies your doubts and also it clarifies others' doubt also, even if they have not asked the question. But is there any further question remains here?
No, sir. Clear.
Clear, na?
Yes, sir.
So very basic thing that you need to keep in mind that for the payment, if the patentee has any kind of agreement with the exclusive licensee or the assigner, then when government is using the invention and they are going to pay the money, they will also pay based on those agreements. So they will also pay to them also. It's not like they will only pay to exclusive licensee. Although these things are obvious in our case, in our dealing, we consider that this is very obvious. It has to be done like that only. But as per the government laws are considered, those has to be in written format. Then only it will become effective. Okay. So 102, acquisition of inventions and patents by central governments. Central government can acquire rights in patent for public purposes by publishing a notification in official gazette. So central government can acquire all the rights of patent for public purpose only by publishing a notification in official gazette. So they don't have to go to and ask for any negotiations or High Court or anything. They can just use it. Notified acquisition will be given to applicant, patentee, or any person appearing in the register. So they will give the notification and they will notify the applicant and everyone. Central government will pay to patentee based on expenditure incurred in connection with the invention, or if work, any profit made, any other relevant factors. So they will take into consideration those things if they are going to make any payments for their acquisitions. Okay, so that's all in 102, 1, 2, and 3 I have covered. This is very simple, right? So they can acquire the rights and they can use it themselves, but they will also make some payments under section 102. And 103 deals in broad way. It gives all the reference to High Courts. If reference to High Court for disputes as to use of purpose of government. So you may get a question like this. Okay, reference to district court of dispute as to use of purpose of government, reference to Supreme Court of disputes as to use of purpose of government, reference to High Court. So your answer would be High Court. Okay, therefore you need to memorize this reference to High Court or any court, district court or Supreme Court. So this says reference to High Court. If High Court can be approached either central government can approach, patentee can approach. So this is very obvious, they can approach, but this has to written format. And if you say where it is written that patentee can approach, so this is written under section 103 subsection 1. So for payment, compensation or acquisition of the patent, as we read in section 102, then government can acquire the rights. Okay, government can acquire the rights and use for the public. And if you're not happy with the acquisitions or any compensation or payments, you can approach government. 103.2 says, in proceedings where central government is party, if patentee is a party, petition by way of counterclaim for revocation under section 64, or may put in issue the validity of patent without petitioning for revocation. Okay, so what it says, that if central government is doing the procedure, what they can do, that they can either go for revocation or they can go for validity of for the patent without revocation. So both things they can do it. 103.3, if the question arises for the invention to have been tested, tried, recorded before the priority date of the claim, as we read in subsection 2 of section 100, the disclosure such fact if prejudicial to public will not be made, will be made confidentially. What does this mean? That if you want to make the proof that please show me when it was tested, when it was recorded, when it was done, all those things are coming up, because if government can prove that this invention, say for example, I will give example. A person was working in a government lab and he started to work on some inventions. Then he realized that this is very good inventions and I can make a lot of money out of it. He resigned from the government office. Okay, he joined, or he opened his new company, and then he started on the invention, and then he made the invention, and then he started money. And government approached him and said, yeah, you started to work on this invention while you were in government office. So government has the right to use this without paying any remuneration. Okay, government can say this. So in those scenario, if some disclosure has to be made, but if this is the disclosure is not proper, then that can be made confidentially, means those will not be made public. So this is what it reads. In case of dispute on the terms of use invention for the purpose of government, High Court will decide for any benefits or compensation. So if there is any dispute, then the High Court will decide. Number 5, the disputes can be referred to official referee, commissioner, or an arbitrator. Okay, so High Court can also refer to an official referee. They can appoint a referee, they can appoint a commissioner or an arbitrator who will fix what need to be done, how much money to be paid. They can refer. If the invention claimed in patent was made by a person on duty in central government or state government, or was an employee in government undertaking, then disputes will be disposed of by central government by giving patentee a chance to be heard. So they will just say, okay, come on, you tell what you want to say, but we have all the proofs that you started this to work on while you was in central government, and then done. They don't need to go to High Court anymore. They can they can do it. So and court can decide if they go to court itself. So if invention was claimed in patent was made by persons on duty in central government, state government, or was an employee in government undertaking, then disputes shall be disposed of by central government by giving a patentee a chance to be heard. So they can ask for clarification. They can come and then say. They don't agree, the dispute is there, then they can always approach the patentee. Central government or patentee can approach. Otherwise, matter will end there only. So this is regarding section 103. So we covered from section 99. So section 99 is very simple. It says meaning of use an invention for the purpose of government. So what is the meaning? If it is used by what? So it says made, used, exercised, and vended. So these are the egg are mentioned, and for the purpose of whom? Central government is also considered, a state government, and a government undertaking. So these are three entities are taken, and what are the egg included? Made, used, exercised, or vended. Okay, four things. And section 100, power of central government to use invention for the purpose of government. This is very simple. What it says, if government will use, they will pay money. But if the invention was done in the central government, while the inventee was or patentee was in the work for the central government, they will not pay the money. Very simple. If there was an employee, he will not pay the money. If he was not employed, they will pay the money. If there is any exclusive licensee or patent is there, any agreement is there, then they will divide the share as per the agreement. Very simple. 100. And 103, 102, what it says, acquisition. Government can acquire the rights and for the public use, but they will also give a chance to them. They will also pay the money. And if they're not happy, under section 103, they can oppose the dispute to the High Court, and High Court will decide. And High Court can also appoint a referee, commissioner, and arbitrator. So this question also comes that in case of disputes, High Court can appoint referee, commissioner, arbitrator, or not. So you need to remember this. And also what government has in their hand, that if you say no, I don't agree with any money that government is paying, I don't agree, then government can go for the revocation under section 64, or they can go for validity trial. Validity trial means they can say that this claim is not valid, so they can go for invalidity cases. They can cite examples. So many things government can do from their side. So this is section 103 we completed. Any question till now? Then we will move for infringement suits in next session. This is very simple and very clear. Okay, so the only few things you need to remember that we just discussed. So anyone remembers under section 64 where it talks about central government can revoke the patent? Anyone can tell?
Revocation of patent by public. Revocation of patent first.
Section 64. So under section 103(2), what we're reading is, in any proceeding where the central government is a party, if patent is a party, petition by way of counter claim for revocation under 64. So they can go ahead for revocation of the patent. Means no much hearing. So in which 64 is given there? You can just open the book. It is an open book exam, not closed book. You can open the book and read that paragraph. If you cannot find, let me know. So it is 64(4). Without 64(4), okay? 64 subsection 4. Without prejudice to the provisions contained in subsection 1, a patent may be revoked by High Court on the petition of central government if High Court is satisfied that the patentee has, without reasonable cause, failed to comply with the request of central government to make use or exercise the patent invention for the purpose of government within the meaning of section 99 upon reasonable terms. Okay. So if government says that that I have requested this person, so this is section 64.4. Okay, you can refer to this. So if government says that I went to the patentee, I requested him a lot, and then also he's not agreeing. He's adamant. He's not allowing government to use this. And if that is the case, government can file petition, and your patent is revoked. Now, what is the challenge if patent is revoked? Can anyone tell? What will happen if patent is revoked? No idea. Are you there?
Yes, sir.
What will happen if patent is revoked? Means if you are a patentee and you did not allow government to use this, and then government went to High Court, and under section 64, subsection 4, your patent was revoked by High Court on petition of the central government. Then what will happen?
And anyone can use.
Correct. Now my patent is not in force anymore. My patent is revoked. Now the entire country can use this invention. Okay. Therefore, it is always best don't fight with government on these topics, because if we agree, say for example, even say for example, you thought that I should be getting 2 lakhs per month as a remuneration. Government says I will pay only 1 lakh, and then you should agree with. Otherwise, if government says that he is not agreeing and they revoke the patent, then you lose all the rights. Then anyone can use the patent. Therefore, it's always advisable that you agree to the government. Otherwise, government can revoke the patent. And then once it's revoked, and they don't have to do anything. For revocation, they don't have to do anything. They just need to file petition to High Court saying that you are asking 2 lakhs, which in our estimate was too much, considering all the expenses and profit, everything in our consideration, and we were ready to pay him 1 lakh. And if High Court is satisfied, then the patent is revoked. Once patent is revoked, then you are done. Or the government can also go for the validity of patent. So if government goes for validity patent, then you have a chance. Means how government can go for validity means patent is granted based on the condition of inventiveness and the inventive step, and then it is new invention, right? Novelty, inventive steps, and no particulars, all those things that we discussed. So they can say it is not inventive, it is very obvious, there's no novelty. Okay, so they can go for those, and then you also get a chance to apply, and then you can find. But if they go for revocation under section 64.4, you don't have much chance. You just have to say, no, 2 lakh was the sum I should have been getting, but government is not ready to pay. And government just need to prove that 2 lakh, 1 lakh was a reasonable payment, and then done. Okay. So I'm discussing more on this topic so that this fixes in your mind. Anything more you want to ask under this, or otherwise we'll move to our next section. Okay, thank you very much.
What is 3? 1033? Can you elaborate a little bit, please?
103?
3.
Yeah. So meaning that if section 100 and subsection 2, what it says that if that patent was before the priority date, okay, if it was made, used, or tested, or tried in the central government or the state government, as the case may be, then government will not pay any remuneration. Okay, but you are fighting to say that this is not the case. In that case, if some disclosures need to be made, but if it seems to be harmful, means if public comes to know about the disclosures, so I don't have any idea that I was working with the government lab, and then this information, it comes to public, it could be harmful to my reputation or other things. So those things will not be made public. It will be conveyed to High Court confidentially. So government will come to know, High Court will come to know, but those information will not be published. Meaning, maybe when High Court publishes their judgment, you will see that they write all the details, what happened, what are the cases, then what. So those confidential part will not be made public. So this is what it means.
Okay.
Okay, thank you very much for this session. So